We are now live. Good morning. This is Friday, February 23rd, 2024. And this morning, Senate Judiciary is taking up S58, a bill that could collectively be called matters related to public safety, more than just what started out as a bill dealing with fentanyl. So it's morphed into several new sections, and one of those sections has to do with the termination of tenancy. And we're fortunate to have John Gray from Legislative Council here to walk us through section 5, which appears on page 5 of draft 3.2.
Thank you. Happy Friday, everyone. John Gray, Office of Legislative Counsel. I'll jump right in. There are two primary changes in this draft. The changes that I've implemented are highlighted, so they should be fairly clear. There is a new section, section 7, which we'll come to. But the two changes, one relates to, there had been some concern that this might be over-inclusive as to drug activity or other activities that don't threaten the safety of others. So I've just made updates throughout to clarify that that is the case. This isn't a change in substance. It's just to make clear that this only applies to particular activities that threaten the health or safety of other residents. The other piece is to address mobile homes, what's done in mobile home park evictions. So section 5 remains the same as it was before, but just to highlight what we're doing there, we've shortened what was previously a 14-day termination notice period for termination based on criminal activity, illegal drug activity, or acts of violence which threaten the health or safety of other residents. This is the first start of the process. This is prior to any eviction proceeding. This is the notice that goes out to evidence an intent to terminate the tenancy. Only upon the expiration of that period can an eviction proceeding commence. So what we've done in this section is just shorten that from 14 days to 7 days for those sets of activities. For section 6, you'll see and highlight this change to include, and this is starting on line 14, any of which threaten the health or safety of other residents. This is just to pull in the language from 4467B2 to clarify that point that this isn't getting at criminal activity that isn't threatening anyone in any way. So not a change in substance, but just for clarity's sake. Section 7 is where the real meat of the changes come in. So this is at the bottom of page 6. This whole new section addresses accelerated proceedings for mobile home park evictions. So to be clear, if you reside in a mobile home park, but the mobile home is owned by someone who isn't the park owner, you are governed by Title IX, and you're already addressed by the evictions language that we've dealt with in the past. But if you are in a mobile home park and you are leasing a lot and the mobile home park owner is trying to evict you from that lot, these are the provisions that would apply in that instance. So there are mobile home owners who are subject to Title IX, and then there are mobile home owners who are subject to Title X proceedings. We just wanted to make sure that there is uniformity across those, or there's at least an accelerated proceeding in each instance. So under section 6237 of Title 10, so this is bottom of page 6, a leaseholder may be evicted only for non-payment of rent or for a substantial violation of the lease terms. This is what's in existing statute, but just want to make clear that unlike Title IX, which provides a whole set of different instances in which you can evict someone. Draft 3.2.
Do we have copies of this?
I thought there was a new folder. Is that 3.2 right there?
No, it's not. It's got my notes on it, so it's obviously an old one.
Okay. Oh, 3.2 is the one that, so the draft that's being discussed right now is the one that Michelle brought in last week, which should be the one on top, I believe.
314.
Okay, yeah. Great. Thanks. Sorry.
Yeah.
You don't want to be citing the language that you don't have. Yeah.
Not finding it, but thank you.
So we're at the bottom of page 6, section 7, and I just want to walk through that there are different bases in Title 10 than there are in Title 9 for eviction. They are more limited. The two bases for eviction from a mobile home park are non-payment of rent or substantial violation of the lease. As you'll see, we defined this specific kind of activity to be a substantial violation, so that's how that's pulled in. The process for terminating is on page 7. So you'll see that prior to the commencement of any eviction proceeding, the park owner shall notify the leaseholder by certified or registered mail, except as provided below, of the grounds for an eviction proceeding. Then for an eviction based on non-payment of rent, that an eviction proceeding may be commenced if the leaseholder does not pay the overdue rent within 20 days. And here's the new piece: for an eviction based on the leaseholder's criminal activity, illegal drug activity, or acts of violence, any of which threaten the health or safety of other residents, that an eviction proceeding may be commenced 7 days following the date of the mailing of the notice. So this is meant to align with that 7-day period that we have set up above for Title IX, the landlord-tenant section. To continue on, so that provides the termination notice period at 7 days. On line 16, a substantial violation of the lease terms of the mobile home park or an additional non-payment of rent occurring within 6 months of the giving of the notice may result in immediate eviction proceedings. So this is different than what's done in Title IX. This is in existing law, but what you'll see the effect of this to be is that if a mobile home park owner gives a resident of that mobile home park notice that they're terminating on the basis of criminal activity which threatens the safety of others, and that supplies that 7-day notice period, if the next day they observe behavior that is the same kind of behavior and they want to terminate immediately, under this subdivision C, that would constitute another substantial violation of the lease terms, and they would be able to proceed immediately to eviction proceedings. So it would be, there's really no cutoff on that. I will say that this is not new to the draft, but this is not new to the statute, but that interaction is new, that we're deeming that criminal activity to constitute a substantial violation of the lease terms. Whether or not that's the way judges would currently treat it is not something for me to say. It may be that currently a judge would say that if you're engaging in this kind of activity, that would constitute a substantial violation, in which case you could say already under existing law, you could immediately evict someone if you encountered 2 in a row, let's say. Does that make sense? Happy to slow down. Okay. At the very bottom of page 7, a substantial violation of the lease terms will be insufficient to support a judgment of eviction unless the proceeding is commenced within 60 days. And similarly, substantial violation based on criminal activity will be insufficient unless the proceeding is commenced no later than 60 days after arraignment. That's what's in existing law. This isn't something that seemed to me to need any kind of acceleration, because this is the instance where it's the mobile home park owner who is presumably incentivized to bring that proceeding. So if you shorten those periods, what might actually happen is that if they missed the window, they would then have to restart the process, and it would actually take longer. So to me, it makes sense, even if you're trying to accelerate proceedings, to leave those 60-day periods in place, which is similar to what's in Title IX. On line 6, this is the deeming a substantial violation piece. Any criminal activity, illegal drug activity, or acts of violence, any of which threaten the health or safety of other residents by the leaseholder, shall be deemed a substantial violation of the lease terms of the mobile home park for purposes of this section, and then language to subject them to the accelerated eviction proceedings process. An eviction proceeding commenced against the leaseholder on this basis shall be subject to the expedited eviction process under 12 VSA 4857, which we'll come to next, but is the language that we have discussed previously.
Who determines if it's in all of these cases, if it's the health or safety of other residents? How's that? Is it determined by the court? Is it determined by the landlord? Or?
So in a way, you could say that it's both. It's the court that will ultimately determine. What will need to happen is the landlord or the mobile home park owner, in bringing the complaint, will need to allege facts stating both that criminal activity or illegal drug activity has occurred, and that it is threatening the health and safety of other residents. So they'll need to provide proof to substantiate that claim, and then the court will determine whether they've met that standard preponderance of the evidence in that case. So the burden would be on the landlord or park owner to bring proof of that fact, and then the court will determine whether or not they've met that standard. And there's nothing in here to disrupt any sort of automatic, we don't have anything in here that would automatically deem a certain kind of activity to constitute a health or safety threat to other residents.
Yeah. I mean, I know what we're intending. It's just I want to make sure we're not getting more than we intend.
Mm-hmm.
for example, somebody who's smoking a cigarette in a leased apartment that's not supposed to be any smoking, I suppose somebody could argue that that's a health and safety issue for other residents, but
Yeah.
it's not what we intend here to evict you for that.
Right, and whether that would be criminal activity.
Yeah, that's
Yeah,
not
yeah.
criminal, so.
So I think you would be okay in those instances. I mean, obviously, we can try to think of sort of edge cases that deal with bad faith landlords or mobile home park owners, but at a point you get to sort of extreme cases that aren't indicative of what we're trying to capture.
Yeah.
But I definitely think it's worth thinking about, yeah.
Where the other residents are in danger because of the behavior of one apartment, lease.
And the language that's used here is what obviously a prior legislator has decided gets at this kind of activity. Obviously, there's room to change that, but this is what that concept is meant to get at. And so
courts are generally familiar with the health and safety of other residents.
I can't speak to what they regularly encounter, and I think you guys did hear testimony that this is sort of an underutilized, or people are relying on no-cause evictions to get at certain kinds of action, but they're certainly familiar with this particular piece. This is not a hidden or obscure piece of law. This is a central part of landlord-tenant law.
I don't want to get ahead of myself, but so if somebody's renting a house, they're not in this.
So the house piece should be covered. If they're subject to a rental agreement, a written rental agreement, the fact that the structure just happens to be a house would not change it. If you mean ownership of a house.
Well, they don't own it. They rent it or lease it. And I'm thinking of we were given information on a house in Pownell that was supposed to be a drug house there. I guess they used the term trap house.
Mm-hmm.
That's what I'm thinking.
So when I'm renting a house here in Vermont, I would be subject to landlord-tenant laws. The basis of the structure would not alter Title IX's application in that instance. So we should be capturing that concern. There are exemptions to the application of Title IX, which I can pull up and walk through if you would like to hear them, but they don't.
If the standard is health and safety of other residents and they're not, they're other residents.
That's right. If you were in a building alone and you're just engaging in your own activity, this would not permit.
Right.
That's right.
Well, if you're the landlord, you could still evict someone for breaking the law or breaking the lease. It just wouldn't, this expedited process simply wouldn't apply.
That's right. So there's a basis for terminating so there is a slight difference between the bases in not Title IX and Title X. So Title X being our mobile home park statute. Under Title IX, if you violate a term of the lease, and I think it's fairly typical for these leases to contain, no violations of a criminal nature, you can terminate on the basis of that. For the mobile home parks, it is more limited basis, so it is this non-payment of rent or a substantial violation of the lease. We are, in this case, deeming this kind of activity to be a substantial violation, so there would be no question that this meets that standard, substantial violation of the lease. But it could be that other activities would or would not. We're just not automatically deeming them in this case.
If they were not the leaseholder, Section 4 could apply. If they're just there and conducting illegal activity in a house, Section 4 could apply.
That's right. So criminal.
Quite frankly, the main group trying to get at with in a house.
That's right. I think that Michelle's sections, the criminal pieces, or the deal with folks outside of a contractual relationship between landlord and tenant, gets at that population, or at least that's the intent.
Is there any way we could get a side-by-side at some point, nothing too lengthy if you don't want, but a side-by-side of what was the previous law and what we're changing here, and the timelines as to how they would be affected? Is
that is doable. I will say that I hope that looking at this draft is indicative of that. This doesn't contain the entirety of section 6237, so you may be missing, there's obviously an ellipses at the bottom of page 8, but So previously, you can see the non-underlined language, say on page 7, indicates the process that would apply under existing law. So this would have this 20-day period from the date of mailing of notice in which they can pay rent. I will note it doesn't set out particular conditions as to what applies for other pieces. So I think in that case, we look to Title IX, and obviously if you wanted just a general overview of Title IX's current landlord-tenant loss eviction process, we can do that. We've done some of that before, but not in like a designated period in which that's all we're doing. I should say that there's a provision to say that to the extent that the landlord-tenant laws are not inconsistent with Title X's statutes governing mobile home parks, they will apply. And so I think that that's what you're seeing on page 7 is to the extent that we're not seeing a process provided for substantial violation of the lease, that would be governed by your landlord-tenant laws under Title IX, in which case you'd have the 14-day periods that we've talked about in the past, the 30-day for, other certain pieces. So I think that the current termination notice period, if we didn't modify this for substantial violation of the lease, would be a 30-day period. And what we're accelerating here to is a 7-day period for this specific kind of activity. If you want a more fulsome.
That makes sense, yeah. Thank you.
Senator Miles, yeah. Okay, go ahead, John.
Sure. The last piece at the bottom of page 8 that I wanted to talk about is that under existing law, the non-underlined language here starting on line 12, a leaseholder shall not be evicted when there is proof that the lease terms the leaseholder has been accused of violating are not enforced with respect to the other leaseholders or others on the park premises. This is presumably in statute to prevent sort of discriminatory behavior where a landlord could get someone out of the park on a basis that would meet the standards for eviction, but the real motivating concern would be they just want this person out of the park. So in existing law, we have this provision to say that basically you can't treat a certain condition as not a standard reason to evict and then isolate one person and evict them on that basis. That evidences some kind of discriminatory intent. But I did want to say that given I've added language here to try to address this for this particular set of actions because some of the testimony that you've heard has suggested folks are having a hard time getting people out. So it might be easy in these instances for a tenant to prove that others in a park are engaging in similar behavior and are not being evicted on that basis. I don't know. So I've included language here to say that this particular subsection would not apply to eviction proceedings against a leaseholder based on that criminal activity, illegal drug activity, or acts of violence, any of which threaten the health or safety of other residents. This is just a question if you guys want to do this, but my thought was if there are concerns about that this kind of activity is rampant or whatever might be the case, that the fact that someone would be in a park and not evicted, you might not want that to be a basis on which you couldn't evict someone else.
So this would lift discrimination protections in this type of eviction proceeding?
So what this would do is it would treat the fact of the absence of evicting someone on this basis, someone else in the park, it would treat that as not indicative of an intent to evict them for any reason other than the fact that you're trying to get them out for criminal behavior. So it's a way of cutting against that judgment that we think, we're suspicious. So in law, there is this provision to say, we treat the fact that you're not evicting others as evidencing something about your intent in evicting this particular person. And yes, so in this instance, it would say, we're cutting against that. We're saying, we're now not treating it to mean that when you refrain from evicting these others, that it means anything about them other than the fact that you are unable to do so. So it's treating it as reading differently is one way to read it. You could also describe it the way that you did. As drafted, what it's meant to recognize is just that it might be difficult to evict others. But conceivably, you could, if you were a discriminatory landlord, and maybe this is the most direct answer to the question, you could conceivably hide that kind of discriminatory intent behind this. That's correct. Does that make sense?
Mm-hmm. And do you know if we have anywhere data on whether it's race data or economic data on eviction proceedings as they are now?
I do not know, and would definitely be worth hearing on this particular piece. Yeah. And to be clear, this was not a specific request. This was just throwing things out as considerations for how you might proceed. No one has asked me to modify subsection B. I just thought it might be a concern given the testimony you've heard on the difficulty of evicting on this basis.
Well, we can think about that as we come back to the bill overall markup. But on its face, it makes sense because every situation is a little bit different. And it may be that it's discriminatory, or it may be that it's completely understandable because they haven't built the proof yet. The police have never been there. It's all rumor about the other apartment. And usually somebody will argue, well, you know, what about him? What about her? But you know, I think you have to have some kind of a standard back in the beginning that there is a legal activity, and I would assume that the landlord has to prove through police reports or whatever that there's a legal activity, and the landlord additionally has to have done something about it. Am I correct in that assumption?
That's right. The landlord would need to prove that condition.
They had tried to do something about it, and so, and you know, we can come back to this section, but I can understand kind of both sides of it, but from the landlord's perspective, maybe they haven't had the proof yet on a particular mobile home versus another mobile home.
So another way to think about or describe it would be to say that for this provision to work the way that it does under existing law, for it to get at impermissible purposes for evicting someone, you would need it to be sufficiently easy for evictions to occur, or you would need to have not such a high burden for eviction to be able to recognize an impermissible purpose. So if the burdens are sufficiently high, it's not necessarily an indication that there is an impermissible purpose. That's another way of thinking about it, is that if there were no standards for evictions and you had this in place, it would be pretty clear that someone's relying on an impermissible purpose in evicting someone, right? Like they could bring on the basis of non-payment, they could bring on the basis of criminal proof, whatever it might be. If there were no standards at all in law and they just could allege this, evict someone on that basis, and then they selectively evicted only one person in their part, it would be clear that they were using an impermissible purpose, right? Because there are no standards. So the only thing to look at there would be, oh, they selected out this one person. At the point that you start to move up the burden of proof or say that we have to reach particular standards, it becomes harder to detect whether or not an impermissible purpose is part of what's happening here. So part of what this would be trying to get at is where that line falls. If it's way up here, it's incredibly hard to prove. It's hard to know whether there's an impermissible purpose animating the selective eviction of particular folks on the basis of their behavior.
I'm asking the housing, I never get the name right.
Yes.
The Economic Development, Housing and General Affairs Committee to look at this. Hopefully when they look at this section of the bill, they'll understand. For me, quite frankly, the key piece is way back on the earlier section of flash citing those that are residing without permission to be there, more so than many times it turns out that the leaseholder is actually the victim. And so, but I do think there are situations where that needs to be addressed too. Is there anything else on this? On your
Nothing substantive. So if you look at the top of page 9, what you'll see are, these are just updates to pull in. This is conforming changes to pick up the updates earlier. This is nothing new in substance, but this is just adding leaseholder language to capture that Title 10 mobile home park language, the clarifying language of health or safety of other residents, and then the relevant statutory citation. Similarly, on the back of page 10 is the same sorts of changes here. So nothing new in substance. This is just conforming changes for the other sections that we just walked through.
Okay. Thank you. Are there other questions for John? Good, thank you, John.
Sure. And if you guys need me to look into anything, let me know. But hopefully this is all clear.
All right, thank you. Ben, would you just work with the committee assistant down in economic development if John and I could come in sometime next week and go over these sections for them?
Yep, I will reach out to them.
Sounds good. Do you have my calendar? I think you do have access. I know my next week is rough.
I don't, but if you can just share.
Okay, I'll share with you because we probably want to get something in on my calendar soon.
Yeah, you're more important than I am.
I'm not sure about that.
Well,
I just have different rooms to be in. Thank you, guys.
Thank you.
I wanted to get Eric is scheduled for 9:45.
I just emailed and see if they
Okay.
can survive.
Michelle, could we just, if you're not prepared, that's fine.
Actually, I have a bill on the house floor, but I have a few minutes because they're just gathering right now, but.
They're just babbling away up there. All right.
What did you want to talk about now?
I wanted to talk about, a little bit about the knowingly again.
Mhm.
If we could just go over what knowingly. I shouldn't have watched Law and Order last night.
One comment to the committee, Jim Waters Dumont submitted a comment from the state's attorney's office on the knowingly language.
Okay.
At the top of your report.
Is Tim in the Zoom?
He's not going until 10:30.
Okay.
And I'm gonna come back later today, and I haven't read Tim's stuff yet, so, but,
All right, well, knowing that Tim is gonna comment on a helpful, thank you. But if we could just, the knowingly is on page 2 of the new 3.2 draft, and it's on line 6. And it's been there since the beginning. I don't believe we made any changes to it.
I don't believe so.
So, current law, as I understand it, the person has to know that there is fentanyl mixed in with a drug, or xylazine, or whatever the compound is. This would make it, as I understand it, this is intended to change that standard so that one would presume that it's there. Since the evidence is that 100% of heroin and a certain percentage of cocaine that's sold in the state has fentanyl, almost everything has fentanyl in it today. So I thought it was aimed at fentanyl, but when the ACLU testified, they suggested it was aimed at everything.
That's correct. So it is, the definition of knowingly that you have in section 1 is to, section 4201, which applies throughout chapter 84, which is the entire regulated drug chapter. So it would apply to all drugs and all the offenses that have a knowingly requirement. So it would be possession, dispensing, and sale, and anywhere that you use a knowingly. So, the drug laws are very formulaic. And so whether it's cannabis, cocaine, heroin, fentanyl's a little unusual because, as you know, when you created the fentanyl statute, you didn't create a possession crime for fentanyl.
Right.
But all the other ones have possession offenses. And the language is very, it's kind of like a, you know, it's a template essentially when it was created. So you see, you know, say a person who knowingly and unlawfully possesses or dispenses or sells. And so knowingly is always the mens rea, the mental state that's used throughout the drug crimes. And so by adding the definition, this new definition of knowingly into section 4201, it would apply to all of the drug crimes. So that's just a policy decision for you, and you can choose to, you know, to just only apply that in certain sections if you want to do that. So if you just wanted to apply it with death resulting or something like that, and that's something you could talk to the stakeholders about, and, you know, they could talk to you about why they feel as though it's important to have it throughout the chapter as opposed to being targeted at certain things. And so I know I've read these to you before, but I'll just again to kind of have the two right next to each other. If I'm looking at some of the notes from jury instructions for in Vermont for knowingly, to act knowingly means to engage in conduct that will cause or that will be practically certain to cause a specific harmful result. And remember, when we're thinking about things, there's like, you have intentionally, which is the highest mens rea, the most difficult to prove. Right below that, you have knowingly. Right below that, you have recklessly, and then you have negligently, which we don't use very often in criminal law, but is there. And so the jury instructions for knowingly under current law is that the state must have proven that the defendant acted knowingly and not inadvertently or because of mistake or by accident. You may find that the defendant acted knowingly if the defendant was aware that their conduct would cause or was practically certain to cause a certain harm. So, and then you compare that to what's in here, and the real, the things that are important there is that I think the consciously ignoring a substantial risk that one or more preparations contain the regulated drug identified and applicable. So, you know, it's fairly nuanced between those two things. So again, it's not, sorry.
So if somebody sold marijuana and it contained fentanyl, they would then come under this.
Well, remember, the state always has to prove that element of knowingly.
That they knew that there was fentanyl in there?
Yes, they would still, so knowingly is, and the mens rea is an essential element of the crime. If you can't prove the knowingly, that's what it all comes down to, is I think what state's attorneys are saying now.
Never would have guessed that fentanyl was.
Right, so I think it would be certainly much harder for a state's attorney to prove the knowingly aspect when it comes to cannabis, because.
So what have we changed here then? That's what I guess, they still have to prove that the person knew that there was a mixture of compounds.
Right, and I think.
What have we changed?
You mean in how it?
Well, it's how it's worded now versus the way it is currently.
Because.
What would this bill propose to change in terms of knowing that?
I think what you're looking at is the language on with regard to the consciously ignoring a substantial risk.
So,
and then I think people.
So that's the depraved indifference.
Correct.
From law and order.
Sure. Yeah. I just wanted to.
I like that term.
So, but I think what will be helpful for you, and I see that Tucker Jones is on for when I come back later today, and then I'll take a look at what Tim provided, because I think he provided some examples. Yeah, I do.
Oh, right, you do have to run, sorry.
No, it's okay.
The knowingly standard, so recklessness comes after knowingly.
Mm-hmm.
Can you share what
kind of
the standard is for recklessness?
Sure.
Because what I'm seeing here is almost as if this is just recklessness, but under the name of knowingly, like it's.
Right, I understand.
Sorry.
No. So the jury instruction in Vermont for recklessness derives from the model penal code. Generally, we don't follow model penal code, but we do in some ways. So, and for that is you may find that the defendant acted recklessly if the defendant acted without regard to the possible consequences of their actions. So with knowingly, it's that the person will be practically certain to cause a specific harmful result. And reckless is acting without regard to the possible consequences. And I'll print before I come back, because I don't think I'll have to be on the floor for long. I can print off some of these things for you to take a look at the language, and then
we can come back to Tucker Jones too on this, and
right. And I think what Tim sent, and I'll take a look at it during the break, some examples. I think what will be helpful is talking to some of the practitioners about, here's a case that we couldn't bring because of these circumstances, and then them talking with them about how they would envision using it, and then trying to suss out, some of your concerns about whether or not lowering that standard on other offenses that might not be your intent, and see if this is targeted enough.
well, certainly death result is priority.
I will just note, and this is a little different, but is like, you do have a different standard on trafficking. You have a permissive inference with regard to amounts of drugs that are sold. So if somebody, remember a number of years ago when you created the trafficking, you kind of said, if someone is in possession of such a large amount of a particular drug, there shall be a permissive inference that that person was intending to distribute that drug. So I'm just kind of offering some other kind of ideas to kind of throw out there.
And so the permissive inference there can only apply to the, what was it, to the weight or the amounts of?
Yeah, I'd have to go back and look, but I was just thinking about that applies to the amount. So like, would anybody have, I don't know, a kilo of cocaine for personal use
Can a permissive inference also apply then to the mens rea of this? Because I feel like it can't.
No, I understand what you're saying there. I think it's a bit of a different thing, but I just kind of introduced that idea about how you have in the drug laws, you do have some certain standards with kind of saying, if there's this particular evidence, then, you can consider it as evidence of the elements that you're trying to prove. So like with regard to the amount, and the jury doesn't have to accept that argument, right? They can or they can't. So it's up to them whether or not to do that, which is obviously different than saying, here's the knowing standard. And if the state can prove that you met the knowingly standard, then.
Thank you.
Yeah. So we'll continue this discussion on knowingly a little later on when Michelle gets back and Tucker's in hand, and Tucker, hang in there, and I believe that state attorneys will also be on board to discuss the knowing. So we're gonna switch to the discussion of the Big 12 and raise the age with Eric, and we have Chris Winters and Tyler Allen, I assume, on Zoom.
No one's on Zoom yet, so.
Okay, well, they're scheduled at 9:45. You want to take a 5-minute break, or? Eric, I'll be. Oh my God, they already took the break.
You said